Every day in the USA, people find themselves in court.
This is case number 2401340NF Acupuncture Health PLLC et al. Versus Farmers Insurance Exchange.
Counsel Prentice for the record.
Good afternoon, Your Honor. Fancy Aldo Hill appearing on behalf of the plaintiffs.
Good afternoon, Your Honor. Mark Gozer for Plaintiff Acupuncture Health.
Good afternoon, Your Honor. Khadija McFadden appearing on behalf of Defendant Farmers Insurance Exchange.
Okay, if we get Ms. McFadden, let's start with the extra corporal shockwave therapy motion.
Yes, Your Honor. This motion is fairly simple, and we argue it on two grounds. The first is that plaintiff acupuncture is not entitled to no-fault benefits because the extracorporeal shockwave therapy treatment was provided outside of the scope of her practice as an acupuncturist. Acupuncture in Michigan law does not include extracorporeal shockwave therapy. And according to old case law, the Attorney General on behalf of the People versus Bino, when analyzing whether a particular activity is within an individual healthcare profession, the focus should be on the statutory definition of that profession and not whether it is included within other professions. So plaintiff argues that just because she's a licensed acupuncturist doesn't mean that she can't perform extracorporeal shockwave therapy. Well, with regard to no-fault law, if she is required to have a license to practice acupuncture, then her services fall directly within the scope of how Michigan has defined that practice. And we point to several sections of the code, MCL 333, 16513, 16525, 16511, and 16501 to show that extracorporeal is not included within that. And even in Michigan, the case law shows that when the courts interpret who is even allowed to practice acupuncture, and this goes to the restriction of what they're allowed to do as an acupuncturist, that even a licensed registered nurse cannot practice acupuncture outside of the scope of being directly supervised by a licensed physician who was also trained in acupuncture. So the courts have made it clear that the scope of their treatment is restricted according to the statutory definition of what it means to be an acupuncturist. And during Ms. Anikayeva's deposition, she testified that acupuncture does not include, per se, extracorporeal shockwave therapy. It's a method separate from acupuncture. And just to take it back a little bit too, the No Fault Act doesn't require coverage for all treatment. The treatment must be reasonably necessary for a person's recovery from the alleged accident. And according to even her testimony, this treatment is not related or reasonably necessary and related to plaintiff's accident. She testified that she provided the treatment because it's just something that she does. She adds, extra benefits in her treatment protocols. And she did not testify that she believed it was reasonably necessary for their care and recovery because of the accident. So on that basis, Your Honor, we argue that the treatment falls outside of the scope of what's compensable under the No Fault Act. And then we argue that apart from that argument, that this extracorporeal shockwave therapy is experimental for musculoskeletal conditions and the fact that the FDA has only approved extracorporeal shockwave therapy for a condition such as plantar fasciitis tends to show that treatment of musculoskeletal conditions through extracorporeal shockwave therapy can constitute an experimental treatment for which efficacy is required under Crone. And we don't have any objective or verifiable medical evidence to show that extracorporeal shockwave therapy is efficacious under the No Fault Act. And Your Honor, we ask that this court grant Farmer's summary disposition for the $13,140 in extracorporeal shockwave therapy charged by plaintiff Acupuncture.
Mr. Duncan.
Yes, Your Honor. Just to take this one argument at a time, the argument that this is not within the scope of acupuncture and that Miss Anakieva testified to that. She testified that extracorporeal shockwave therapy is not acupuncture. And the definition in the statute, it does define specifically what acupuncture is. However, there is also a definition for the practice of acupuncture, which is 333-16-501-1H. The practice of acupuncture means the use of traditional and contemporary East Asian medical theory to assess and diagnose a patient. And then it also actually defines East Asian medicine techniques, which is 333-16-501-1H. East Asian medicine techniques includes, but is not limited to, acupuncture, manual therapy, heat therapy, dietary counseling, therapeutic exercise, acupressure, cupping, it goes on. What Ms. Anakieva testified is that the shockwave therapy is not acupuncture, but it's within, she uses the phrase, the scope of acupuncture, meaning that the treatment is part of the practice of acupuncture, even though it's not acupuncture itself. And the statute does specifically state that manual therapy, therapeutic exercise, those are all East Asian medicine techniques that are considered to be within the practice of acupuncture. So it's our position that since it's within the practice of acupuncture, as she testified, it's compensable. The other argument that this is an experimental treatment, we cited a couple of peer-reviewed studies done by a couple different medical journals, one by the Journal of Orthopedic Surgery and Research that found it was provided better pain relief and improved lumbar dysfunction compared to other interventions, and also a randomized control trial by the Biomed Research International Journal.
What year was that?
The year for give me 1 second, I'll pull them both up.
For
here.
each one, yeah.
The year for the first one I mentioned was 2023. And then the Biomed Journal, my apologies, Your Honor, I got to find it in my exhibits. One was 2023, the other one is 2021. So both of those show efficacious results of extracorporeal shockwave therapy when it comes to spinal cord injury specifically. So based on both those arguments, Your Honor, we believe that this motion should be denied.
Thank you. Ms. McFadden?
Yes, Your Honor, thank you. It's important to note, Your Honor, that Ms. Anakieva, the owner of Plaintiff Acupuncture, she testified that extracorporeal shockwave therapy was separate from acupuncture. She testified that she is not a doctor. She testified that extracorporeal shockwave therapy doesn't require prescriptions, that her acupuncture education did not involve extracorporeal shockwave therapy, and that she even believed extracorporeal shockwave therapy was relatively new treatment. Your Honor, she did not state or claim that extracorporeal shockwave therapy constituted a form of East Asian therapy, for which she's licensed to provide under the scope of her license in Michigan. So we vehemently object that argument. There were charges for cupping that was for plaintiff Albert Baptiste and Carol Freeman, which we do not contest because that's clearly indicated within the scope of being or providing acupuncture under Michigan law. So that's not contested. What's contested is the fact that in order for her to practice acupuncture in Michigan, she needs a license. And under her Michigan license, she's not licensed, or extracorporeal shockwave therapy is not included as a form of acupuncture, and that she doesn't have any type of license or specialized training to perform this therapy. And so, Your Honor, it doesn't constitute compensable medical treatment or even legal medical treatment under the No Fault Act, because it's treatment that was provided outside of the scope for which she's licensed to render treatment under the No Fault Act. So, Your Honor, we ask that you deny or grant our motion on that basis and deny plaintiff relief for payment for those treatments. And with respect to the experimental nature of this treatment, it goes a long way to show you how this treatment is still experimental, in that there is no FDA approval for treatment for musculoskeletal conditions, only treatment for chronic plantar fasciitis. And Ms. Anikayeva testified that she didn't treat Albert Baptiste or Carol Freeman for plantar fasciitis, and that she didn't have any clue as to whether or not the device she allegedly used had any sort of FDA approval. When probed about this, she said, oh, the manufacturer said it was FDA approved, but she still hasn't produced any evidence that the manufacturer she purchased this equipment from had any FDA approval correspondence in any way. So, you know, we still ask, Your Honor, that on that basis as well, that our motion is granted, and we'll rest there.
Thank you. Ms. Hill, did you have anything you need to add?
I haven't, the other motion is regarding my client, Judge.
Okay, all right, thank you. The court has to take the evidence in light most favorable to the non-moving party, and this was a motion that was brought on multiple fronts. One relative to the provider not having license for the extracorporeal treatment, and two, there's outside the scope of the provider, even if she's an acupuncturist. And then we have the argument that the extracorporeal treatment is experimental in nature, and that its efficacy has not been substantiated. Okay, I forgot which one I said first. Well, one, there hasn't been anything to support or substantiate that an individual who is a licensed acupuncturist can venture into the arena and provide, without supervision, the extracorporeal shock treatment. Additionally, there has not been anything to substantiate the fact that this is anything other than experimental. In terms of the fact that additionally, that it has not been FDA approved, and there's not been any documentation to support or substantiate that this falls within the scope of acupuncture. That's it. So even taking evidence in light most favorable to non-moving party, the court finds that there's no sufficient basis to proceed as to the extracorporeal shockwave therapy treatment, and the court will grant the motion for summary disposition as it relates to that. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor,
Okay.
if it's all right, the other motion doesn't have to pertain to me, and I have another call I have to be on. Is it okay if I
Okay.
log
Yeah.
out?
Yes. Okay. Thank you. Thank you, Ms. Gosher.
Thank you, Your Honor.
And Ms. McFadden, relative to that issue, the court will look for the order to be submitted to the court today. Thank you very much. Thank you, Mr. Gosher.
Thank you, Your Honor.
Yes, Your Honor.
Okay. Let me see. Granted as to extra. I'm writing this on the precipice. Which either one, Ms. McFadden, either the wage loss or let's do wage loss, because the other one's attended care and replacement service.
Well, Your Honor, she pardon me, she stipulated to withdraw those claims so that
Which one?
the
The housekeeping
care one.
The
replacement
household
service. Yes,
and the
Judge.
attended care?
Yes, Your
Yeah,
Honor.
it's just the wage loss motion that we have this today.
Okay. All right. So did you
See,
all
Judge?
submit a stip to this?
Yeah.
Did
I
I
have to,
say?
Your Honor, we should have. I will make sure we do.
Okay, so what I'll say is that is dismiss stipulated order to follow, right?
Yes.
Okay, thank you. Ms. Hill, did you have something you wanted to add before we started, or?
Judge, I was just gonna see I'm reasonable. I get rid of some of the motions. Try to help.
Appreciate it, thanks. Order, stipulated order to dismiss. H. Okay, yeah, but Ms. McFadden, please present that order today as well.
Yes, Your Honor.
Okay. As to the wage loss?
Yes, Your Honor. So this claim is about Albert Baptiste stating that he's entitled to wage loss, but not providing any proof that he was employed at the time this accident happened. Plaintiff alleges that the Michigan courts do not require proof of wage loss, but plaintiff is wrong. He has a burden to prove by a preponderance of the evidence the damages sought, and his uncorroborated testimony does not create a question of fact. He claimed that he earned $400 per week as a barber, testified that, pardon me, Your Honor, he hasn't offered any proof that he earned $400 per week or that he actually worked as a barber. He said that he missed 5 weeks of work, but he didn't offer any proof for that. And he also claimed that he worked as a laborer for Wilfred Nichols. Wilfred Nichols is allegedly his longtime friend and the person's vehicle he was driving when this accident happened. However, he hasn't offered any proof whatsoever that he worked for Nicholas. that Nicholas paid him about $700 per week, give or take, depending on their business practices. He hasn't offered any affidavits, just nothing, absolutely nothing. And so, Your Honor, plaintiff requested $67,745 in wage loss benefits without any proof whatsoever. He also initially denied during his deposition that he ever stopped working as a barber. Then later on in his definition, he said, I may have taken off a month. But we just want to point out that his contradictory deposition testimony can't create a genuine issue of material fact sufficient to defeat summary judgment. Even if this honorable court took his statement that he took off of work as a barber for about a month is true, he still hasn't produced any evidence whatsoever that he worked as a barber or took off, or that even taking off for a month was necessary for the accident. He claimed he had to undergo extensive physical therapy at Michigan First Rehab. We'd like to point out that it was at Michigan First Rehab that he also underwent extensive nerval matrix and class 4 laser treatment, for which we filed an MSD and it was granted. And the amount granted total over $800,000. So the fact that he's claiming he underwent extensive treatment at Michigan First Rehab doesn't actually help his case. It helps ours. His treatment was not reasonably necessary as it relates to the subject accident. So him taking off of work because of his treatment there does not support his claim. And so, Your Honor, our argument is simple, that plaintiff bears the burden of proof to show that he sustained actual loss of earnings with specificity. But in this case, we don't have any evidence other than his deposition testimony. And so, Your Honor, we ask that this honorable court grants our motion for summary disposition.
Ms. Hill?
Thank you, Your Honor. So Judge, as you know, Ward versus Titan, I don't need anything more than his deposition testimony that is with specificity. They asked him all kinds of questions. How many days per week? How much per week? How much per month? Who did you work for? He wasn't working for himself. This is not self-serving testimony. This is, I worked for this individual doing home care. They had the opportunity to depose him. He's going to be called at the time of trial as a witness to talk about our client, Mr. Baptiste, working for him since 1993. This isn't like a job he got a month before the accident that's not verified. They had ample opportunity. You gave them all kinds of discovery time to take this man's deposition. They didn't. He's going to come into trial to testify as to Mr. Baptiste's wage loss, that he was working home improvement for him. He was in his car when this accident happened, doing his job. And he asks you how he pays you. He says cash. He's been working there since 1993. They asked him how many days a week. He said 5 or 6 days per week. And he makes about $700 per week. Sometimes upfront, sometimes in chunks, about $2,000 a month. This isn't a guessing game. This is an individual who has a witness that's going to come testify. This is in light most favorable to the plaintiff. I don't need, cash jobs are allowed under the No Fault Act. There's a lot of people that work cash, and just because they're working cash doesn't mean they don't have a wage loss claim. So, this isn't a surprise to them. They've known who he worked for. In terms of being a barber, I mean, Judge, it's 5 weeks at $400 per week. He testified, and then he mitigated his damages by going back to work as a barber because, like he said, I got bills to pay. So, I don't need stubs. I have his testimony. I have a witness that's coming to trial to testify, and this is in light most favorable to the plaintiff. Ward v. Titan outlines the No Fault Act as terms of wage loss in black letter law.
Okay. Ms. McFadden, any reply?
Yes, Your Honor. So plaintiffs' need to have wage loss benefits is undercut by the fact that he still admitted that he went back to work as a barber, even if it was within a month or 5 weeks after the accident. Plaintiff will be hard pressed to prove that he needed work loss in the first place if he was still continuing work as a barber. Beside that point, though, Your Honor, it is plaintiff's burden to prove that he is entitled to the benefits he seeks. We brought our motion and stated plaintiff has not offered any proof. Plaintiff comes back with, I said what I said during my deposition without any affidavit, any proof whatsoever that he made earnings with his friend Wilfred Nichols. Again, Your Honor, it is not farmer's responsibility to prove plaintiff's case for plaintiff. It's plaintiff's obligation to prove their case, especially at the summary disposition stage, where they know that they cannot rely on mere allegations, that they must come forth with documentary evidence to overcome our request, and they just haven't done that. They haven't showed this court why he is entitled allegedly to $67,000 in wage loss benefits from his alleged job at Wilfred Nichols when he was still working, standing on his feet as a barber, and when he didn't even get from his alleged longtime friend since the 90s a mere affidavit claiming that he had been working for him for that time period, that he was not able to return back to work because of the accident. And might I add, Your Honor, I didn't say this initially, plaintiff also did admit that he still went back to work with Wilfred Nichols, just in a reduced capacity. That's what he said. So the whole issue is that plaintiff hasn't produced any proof to substantiate his claim. It is not farmer's position that somebody's doing something illegal by getting paid cash. It's farmer's position that if you claim entitlement to wage loss, that you have to produce some type of proof of that claim. And here, plaintiff has not, and defendant rests.
Okay.
Judge, just briefly, I didn't know but getting paid cash was illegal. Secondly, it's my burden at trial to prove his wage loss claim. I have enough to pass summary judgment today in terms of the genuine issue of material fact between his deposition testimony that they took and my burden of proof is at trial, which I will meet that burden of proof. But you know, the case law under Michigan law for wage loss goes as far as saying even temporarily unemployed is a claim for wage loss. So they don't, they don't limit just because you don't have pay stubs or Venmo, screenshots that you can't make a wage loss claim. They say even if you're temporarily unemployed, you can make a claim. How else can you do it without the plaintiff's testimony?
Okay. The court has taken evidence like most favorite to non-moving party, and what we have here is we have a situation where the deposition of the plaintiff was taken. And I know Ms. McFadden is looking at the fact that she doesn't have anything tangible, but all that has to take place at this juncture is that the claim has to be made. And when it goes to the jury will make a determination as a trial of fact whether or not the plaintiff has sustained their burden to go forward. And of course, this is going to hinge on a issue of credibility. How credible do the jurors think that the plaintiff is in this situation? And what proof will be presented is up to the plaintiff to make that determination. But in the discovery phases, we know in the case law supports that you don't have to provide anything other than the basic information. And if Ms. Hill is going to present something at trial, she has that right to do so going forward. But still, and I have to take that as light most non-moving party in the light most favorable to the non-moving party. And in this situation, there's there's conflicting opinions on both sides relative to what transpired. One, and as I indicated, the jury will have to make a determination as to the credibility of the plaintiff. And in doing so, that would create a question of fact that must be submitted to the trier of fact, in this case being the jury. So the court is going to deny the motion as it relates to the wage loss of Bernie McLean. I'm sorry, right? What's his name?
Albert Baptiste, yeah.
Albert what I was thinking. Albert Baptiste.
Sounds good, Judge.
Okay, so that one's denied. Give me 1 second. Where's my sheet? And you all did not today. Well, wait. Let's see. Give me 1 second.
Judge, if it helps, we have a settlement conference April 21st.
That's what I was looking for.
Yep, at
Okay.
11.
Okay.
You wanted to do these motions first.
Prior to. Okay, great. So if you all can have conversations before then and make a determination how you want to proceed, that will be great so that we'll know exactly where you are and where you plan to go when I see you in April.
Okay, sounds good.
Okay, thank you both.
Thank you. Thanks, Judge. Bye-bye.
Take care.
I am the very model of a Michigan acupuncturist. I bill for shockwave therapy, though it is not on the legal list. It's $13,000 for a wave that is not FDA approved, except for plantar fasciitis, which the plaintiff hasn't proved. Oh, Farmer says they will not pay. The treatment is experimental, while Albert claims his barber cash is strictly incidental. Is it East Asian medicine, or fully outside of her scope? The summary disposition's granted, now the plaintiff has no hope.